Number 10, People v. Ali Cisse.
Matthew Bova for Mr. Cisse. I'd like to reserve 2 minutes for rebuttal.
Yes, of course.
I'd like to switch gears and focus on a narrow issue, which is the 60-45 voluntariness instructional issue. And then I'd like to cover the DeBoer issue. In this case, counsel expressly requested an instruction quoting the text of 60-45-2A on voluntariness.
What was the evidence of involuntariness that was adduced at the trial?
Mr. Cisse is a 17-year-old, at the time of his incarceration, a 17-year-old boy. He's incarcerated on an isolated island, cut off from friends and family.
I get all that. Was that what was produced? Was that the evidence that was produced at trial, that he didn't have any visitors, he didn't have any phone calls? Is that what you're telling me?
No, there were phone calls, but it's the isolation that creates, and I want to focus very closely
But I guess traditional voluntariness, right, to use the most extreme example, is you beat the confession out with a rubber hose, right? And I think what the chief is getting at is what evidence was introduced at the trial by which a jury could find that this was involuntary in the traditional sense.
Well,
I mean, it's not a Miranda issue. It's it's that kind of 60-45 traditional involuntary.
Well, a rational jury could find involuntariness under the statutory text, and that is the dispositive issue. And I want to just focus on the plain meaning. The plain meaning of this.
So is it your position then that every time you make a request for a voluntariness charge under 60-45 to be submitted to the jury, you must give it?
When there's incarceration.
Just read the statute? I mean, I don't think that's what you're saying.
Well, when there's incarceration at Rikers Island and counsel expressly requests it, yes, because there is an issue of fact. The statute says that a statement is involuntarily made when it is obtained from him by any person by means of undue pressure, which impaired his mental condition to the extent of undermining his ability to make a choice whether or not to make a statement.
What about interrogation? Doesn't this impact interrogation, 60-45, or no?
No, the 60-45-2A expressly does not require interrogation. It simply says that a person...
Does it require a conduct that would prod a defendant to make an incriminating statement?
It requires undue pressure by a person. 10.007 defines a person...
And your position is being housed on Rikers Island fits that test?
Yes, it does. There's an issue of fact that should have gone to the jury.
Every 17-year-old?
Certainly for every 17-year-old,
For every
yes.
18-year-old?
Yes, I don't think age is
For every
dispositive.
21-year-old?
Again, I don't think age is dispositive.
So every 50-year-old career criminal?
That might be a different case, but the bottom line here is that Rikers places Mr. Cisse, the government and a government instrumentality, DOC, places Mr. Cisse on an isolated island and says, either use our wiretap system or be cut off from the outside world.
He himself knew he had other opportunities.
He can talk to people. He may not be able to make incriminating statements, but he can certainly talk to people about what's going on in the neighborhood and, how's mom and, stuff like that.
No, but his choice to make statements on the wiretap system is the product of undue pressure. Because if he doesn't use...
We're talking about isolation being that coercion, that pressure.
Yes.
So, and I'm saying it's not isolation. It does require a choice as to what you're going to say and to whom. There's no question about that. But it's not the isolation, I think, as you're describing it.
Yes, the isolation forces the statements, funnels them onto the wiretap system, because if he doesn't use that system, he's cut off from the outside world. That is an issue that should have gone to the jury. Perhaps the district attorney could say, well, you can write letters, you could have visitors, but that is the classic factual issue that should go to a jury. And all we're asking for is a jury instruction on that question, so the jury can assess that undue pressure. And here, the rational jury could have certainly found that the statutory test was satisfied. Also, just to go back to the issues that were discussed in the prior case, there was lots of discussion about expectation of privacy. That's a Fourth Amendment doctrine. Mr. Cisse's counsel preserved state and federal wiretapping claims. Under that analysis, expectation of privacy is irrelevant. The statute does not require that. So any analysis in that case as to expectation of privacy does not cover this case.
And also under that argument, which I understand you've preserved here, a finding for you in that case would prevent the use of these tapes at all.
Well, that's our broad argument in terms of, yes.
That's your argument under the wiretapping statute, because
Yes.
if it's illegal under the wiretapping statute, you can't use it. In fact, if you used it to prevent a riot, you'd be subject to civil suit, because you're using illegally obtained evidence, right?
Yes, under the wiretapping statute, the state and federal legislatures have held, and it's conceded that the wiretapping statutes apply to Rikers Island. So yes, if the statutory standards are not satisfied, that evidence is inadmissible. As to the DeBoer issue,
Not only inadmissible in the criminal case, the prison can't use it. I mean, nobody can use it if it's a wiretapping violation.
well, the acquisition would be illegal under the wiretapping statute. But our narrower argument is that as to scope of consent.
But that's not your wiretapping argument, is it?
Yes,
I mean,
it is.
because wiretapping is consent or not consent. Like you say, it's not a Fourth Amendment issue. It's a statutory issue. So either you consented or you didn't.
No, but
Not
under
a
the
partial consent under the wiretapping statute.
But under the wiretapping statute, the wiretapping cannot exceed, assuming we're in the consent under the consent analysis, the wiretapping cannot exceed the scope of consent. So the statutory analysis.
What could Rikers do? What kind of notice, if any, could they give to avoid wiretapping and be able to monitor calls for security purposes? Is there anything they could do?
Well,
Because your first argument seemed to be if you're held at Rikers, you can't give voluntary consent to anything.
Yes, that's our first broad argument is that notice does not equal consent.
Well,
but as to the limited argument,
What could they do?
well, under that argument, they
Does
could.
Rikers have a legitimate need to be able to listen to phone calls made by inmates to make sure they're not bringing bombs into Rikers?
Rikers can, if Rikers has probable cause, they can get a warrant, yes. But beyond that,
But
if the
otherwise, they can't just monitor the calls to make sure nothing's happening.
no, they can't engage in dragnet surveillance under our first broad argument.
And there's no way that they could get any sort of consent from anyone who's housed there that would be effective.
Well, no, if someone affirmatively consented by virtue of saying,
But
I understand you'd like to listen to
they're under
me.
undue pressure because they're being locked up there with no ability to, if I understood your first argument correctly, no one can give voluntary consent if they're at Rikers.
Yes, I mean, we have several arguments here. But so in terms
They all
of
work together.
No, but, well, if, our first argument is that Rikers cannot acquire these statements because the wiretapping statute's prohibited. But if that argument is unsuccessful, then we have a narrower argument, which is they can acquire the statements so long as they provide the notice that this court referenced in Johnson, which is prosecutorial access. Because then it's ensuring that the notice that is provided is covering the acquisition.
But I think in part what you're being asked about, at least with respect to that particular argument, is, but if they're under so much coercion and pressure, and as I called it before, hell on earth, when would they be able to give consent? Under what circumstances could they consent?
Well, if someone,
Under the argument you're making.
if someone has a long history of experience with Rikers Island and they've been there for a very long time, they're not new to the system like Mr. Cisse was, then it might be a different analysis. But Mr.
Do
Cisse,
they become numb to the hell on earth?
no, they don't become numb to it, but the circumstances change. I mean, your experience and the application of that undue pressure is going to change. But to resolve all those problems in terms of broader issues as to whether they can acquire it, our narrow argument is that all we're asking for is the instruction. That's a narrow argument under 6045. Just let the jury assess this.
So let them
so-
record it, let them use it, and disseminate the recordings to the ADA or whoever else they want to, as long as you get the instruction.
Well, we oppose that, but our narrow argument is that the instruction in this case
If we're going to
requires
permit
reversal.
that, then you got to get the instruction.
Yes, if that is going to be allowed, if the acquisition of the calls is going to be permitted under the federal and state wiretapping statutes, then what has to happen is a jury has to be able to consider the rational theory that exists because
What if the people get a warrant or a subpoena for the calls? Do you still have to get the jury instruction?
Yes. Yeah, because the warrant is only relevant to the question of the federal and state wiretapping statutes, because the warrant is the touchstone of that statutory analysis. But the 6045 2A analysis, the analysis of the warrant is irrelevant. That's simply asking the jury to focus on When someone is at Rikers Island, what kind of choices are they faced with? I mean, Judge Piggott recognized this in Johnson, and federal judges have recognized it as well. I mean, from Chile, a prisoner either uses institutional phones or is cut off from the outside world. It tortures the meaning of the word to call it consent. Another federal judge, prisoners are faced with the Hobson's choice of consenting to having their private calls.
Your red light's on, so I just want to make sure, is there anything at all that you want to tell us about the De Boer issue?
Yes. The first thing is that there was LaFontaine error in the appellate division, and this court should reverse on those grounds. But alternatively, Reyes should be revisited, because Reyes clashes with the basic reality of police-citizen encounters.
Well, but then is there any, then there's no way you're saying there's no way that a police officer can ask someone to hold up or stop or question them in any way without a much higher level of suspicion or cause, right?
All we're saying is that there has to be founded suspicion. That's it. All we're saying is that the police cannot go out on the streets and base purely on a level 1, the lowest level possible. It's almost impossible to fail to satisfy level 1. Based purely on that, they cannot go around and ask.
The argument turn on whether or not the officer asks or commands.
It's a command. I think the command.
So if the officer, if there's a fact finding that here what the officer did was ask, do you lose on this issue?
No. Well, no, because that fact-finding has that. If that were the finding,
yes,
there would be no rational basis in the record for that. This is an officer darting out of a car at 12:15 at night and directing someone.
Didn't the officer testify that he asked?
The officer testified. The officer testified that he said, "Stop, hold up, turn around."
He said, "I asked
Wait a
him
minute,
to
wait a
stop."
minute. But if we're going to go by findings of fact, and we look at 8202, I think what JHO Adlerberg said was, and he approached and told the defendant to hold up. Nothing about turn around. The testimony may be whatever the testimony is, but those are the findings of fact. Now, I know that there is reference in the appellate division to the turnaround. Does that matter? And is the appellate division then invoking different fact-finding than was made by the JHO?
Well, I think you could look at it in two ways. First, the appellate division fact-finding is going to supersede the lower court's fact.
They don't say that. That's what they're doing.
No, they don't. And I actually think it's actually academic in this case, because the record only supports one conclusion, which is exactly what the officer testified. On page 103, when you got out of the car, 2 seconds went by, and then you asked him to stop, correct? Answer, correct. A107 to 108, testifying that when he approached appellant, the officer had, quote, already asked him to hold up and turn around.
Right.
So what
it does
have
say ask. Thank you, counsel. You have rebuttal. Go ahead.
Good afternoon, Your Honors. May it please the Court. My name is Susan Axelrod, and I represent the respondent. I was going to start with the Rikers Island calls, unless the Court would like me to start with the De Boer.
It's your argument.
Okay, well, it's the Court's questions that I want to make sure
See how far you
that
get.
I'm sorry?
See how far you get. Go ahead.
Okay. In terms of the voluntariness, there was zero evidence on the record in terms of the isolation beyond the fact that this was a prisoner at Rikers Island. There was no discussion of his inability to communicate with his family. There was no discussion of family and friends who wanted to come but couldn't come. It was the defense attorney saying, look, the notice in this case, because he's in Rikers, isn't sufficient for consent, and we want a voluntariness charge. That is so far removed from what the statute itself requires that the court was correct in its determination that it would not give the charge. What counsel's now essentially saying is any time we have Rikers Island calls, as a matter of law, every defendant should be entitled to a voluntariness charge. Aside from the broad sweep of that, that's a completely unpreserved complaint, because below, defense counsel never suggested that the use of Rikers Island calls goes hand in glove with 60.45. In terms of the discussion about consent and the limitations of consent, the bottom line is, in order for the prisons to intercept these phone calls, they have to bring themselves within the New York State wiretap statute. The way our wiretap statute is drafted, unlike the federal statute, the only way they are entitled to listen at all is if they obtain the consent of the defendant, of the prisoner. Under the wiretap statute itself, it does not state anything about the limitation of use of calls. It merely focuses on consent. Now, when you think about the wiretap statute, that is a statute that anticipates the use of those calls at trial. So implicit in the consent of the wiretap statute is that those calls are going to be used at trial. The legislature clearly did not see reason to bifurcate the consent and say not only do you have to consent to the recording, but you also at that time have to consent to the dissemination to the prosecutor.
So then the notice is misleading? That says it's being monitored and recorded for public security purposes? You're saying that's misleading?
No, not at all, Your Honor. They're explaining why they're asking for your consent. But the bottom line is they need to ask for your consent. They didn't have to put in that they're monitoring it for security purposes, but they gave the defendants that information. That's separate from telling them, we need you to consent to this recording in order for you to use those phone calls.
That's our rationale. The for purposes of is DOC's
Exactly,
rationale.
it's their rationale.
But there's not a Fourth Amendment claim in this case, correct?
There is not, and
And so then I'm not sure why, I think maybe you're doing more work than you need to do, right? That is,
well, I'm happy to sit down.
Well, I mean it that way. I'll keep you up here for at least a minute longer. If this is just a wiretapping claim, if there's consent to the recording, the wiretapping, for any purpose, that ends the inquiry for the wiretapping, right? I mean,
Correct.
It's not whether the wiretapping statutes were enacted with the expectation they would be used in court or not seems sort of irrelevant. That's maybe relevant to a Fourth Amendment inquiry, but that's not, there's no argument about that here, right?
That's correct, Your Honor.
So we don't worry about what the scope of the consent is. If there's consent for anything at all, that's consent to the recording, and that ends the story, no?
That's exactly correct, and that's the point that we're making. In terms
Did he
of,
make a due process argument?
he made a due process argument, but his due process argument had nothing, I actually would have to go back and double-check his due process argument, but his due process argument was, actually, I'm blanking on his due process argument. If you can give me one moment, I'll just double-check the...
I thought the argument there was that it wasn't preserved. I thought that's what you were
Well,
arguing.
the due process argument
Yeah.
he's trying to make now was not preserved. His current due process argument is, I can't facilitate my defense because my client is, I, as a defendant, am worried about calling witnesses.
And I thought there was a right to counsel argument regarding the recordings also.
That's correct, and that, the defendant is, again, asking this court to extend the state right to
Constitutional
counsel.
right to counsel to cover.
Which this court has not seemed inclined to do, did not do in Johnson. In fact, extending it in this manner would push Velasquez way beyond all of its boundaries.
But he didn't raise, I thought he raised due process and standards of fairness. I thought both defendants did that, but we're only talking about Mr. Cisse.
He made a general statement that for people in prison, they are going to be talking about the case, and as a result, the admission of the calls give rise to equal protection and due process issues. That is what he said.
And can you address that argument?
Yes.
He said that to the trial judge, or he said that to the appellate division?
No, he said that to the trial judge.
Okay.
The notion that due process is violated by allowing Department of Corrections to engage in the security measures that it needs to keep itself safe. That's the balance.
No, I think the point was the dissemination to the people for purposes of bolstering their case that's pending against the individual.
I understand
The argument
that.
is not about the public security of the facility.
Well, he
They have
actually-
no grounds to challenge that.
He actually made that in the context, I believe, of just the general wiretapping and not actually turning it over to the prosecutor. But the bottom line is, the prisoners
But now we're
have...
talking about this due process argument.
I understand that, Your Honor. But the bottom line is, well, it's certainly correct that it is more comfortable to be out of jail than to be in jail. Any defendant actually faces the problem that anything they say about the case to anybody outside of their spouse is now fair game to be...
Yeah, but the difference is that if they had the money to post bail and get out, if the ADA wanted this, unless, as you say, the third party wants to give it up after having a conversation, they have to get a warrant.
If the
They'd
ABA...
have to take some, would they not have to do something else? They can't just record, right? They can't just record their phone
Oh,
conversations,
no, that's not
correct?
actually what I was saying.
No, but that's what I'm saying.
I
That's what
understand
I'm
that, but when
saying
you're
is the
talking about
distinction.
a due process argument, you're also talking about a balancing of factors. And one factor is that there is a security risk. And with that factor comes the fact that the state actually has some rights and protections it's entitled
Yes,
to
to
take.
protect the facility, I understand that. I'm not asking about that. I'm asking you about the people getting access to these calls.
That, unfortunately, is all part and parcel of being an incarcerated defendant.
And that's the question. Why is that so?
Because
he makes
there
a due
is-
process argument that if he posts bail and he gets out, that the people have to do something else. They can't just go around recording their calls.
No, but we can also go around and talk to every single person that he talks
You
to.
could,
And
and you could have done that when he was at Rikers.
we could do
all those things,
many
but
of those
that's not
things,
what
but the bottom
happened.
line is, no defendant is simply free to go about talking in the way that he wants. And in this particular case, this defendant can certainly talk to his...
You mean then they don't have to consent?
If
There's
you
no consent
confess
requirement?
to a crime to me, and the prosecutor says to me, I'm putting you in the grand jury, and I want to know what Judge Rivera said, you didn't have to
No, you
consent
just
to
said
that.
they have no right to say anything they want. So my question is, you're saying that they have no expectation of any privacy, so there is no requirement for consent? Is that the people's position?
I think I've made my position clear,
No,
Judge.
but I'm
When you're
asking you
talking-
again then, perhaps
When
I
you're
need
talking about
clarification.
out defendants,
No, at Rikers.
and I'm not understanding your question.
Perhaps I misunderstood you. I thought you had made an argument that a person who's at the time detained can't really just say anything they want.
Well, they can say what they want, and they can also guard against use of incriminatory evidence by not discussing the case with anybody but their lawyer.
But you agree that consent is required?
Maybe I'm mixing this up.
I'm sorry, I'm still not understanding. So you're just
Your
getting...
position is that docs didn't it was not
Oh, no, no,
necessary
no.
for docs to get consent?
No, that's not my
Okay,
position.
well, that's
I'm
what I
sorry.
was trying to clarify.
We were at cross purposes.
Okay,
No.
that's fine.
Docs cannot listen to a single phone call
Without
unless it comes
consent.
within the wiretap statute.
Okay.
And here that means consent.
Okay.
I'm sorry, that's absolutely correct.
That's what I thought your position
Okay.
was. Okay.
I'm sorry, just fine? Were you...
I was just going to clarify factually. In this case, he actually knew that he was being recorded because his statements indicate that he knew he shouldn't be making incriminatory statements.
Not only that, but this poor 17-year-old, who, by the way, committed a gunpoint robbery. Well,
That's irrelevant.
If defense counsel is going to play on the heartstrings, I think it's fair game for me to just point out something else. When he used the phone, one of the things he was doing was engaging in the destruction of evidence by making sure that his co-defendant had gotten rid of the gun. Not only did he do that, but he used code to do that, referring to the gun as Shalom, which was clever, but it was code, which suggested that he was well aware that somebody would be listening and maybe using these calls down the road. And then he said elsewhere, I'm not talking on the phone.
Right.
So yes, this defendant was well aware.
He wasn't as naive as some would paint him. But anything else you want to say, because I see the red lights on the Boer issue?
Well, the judge's ruling was a little bit convoluted. Given the nature of the arguments that the people made, it's our position that the judge was actually finding this as level one.
And that's what the appellate division,
That's what the
using
appellate division
Nicholson, clarified.
Yes. And then the appellate division agreed with that. The police officer's testimony was that he got out of his car. He didn't come charging out of the car. In fact, they said he got out of the car and waited several seconds before he said anything. He said, hey, hold up a second. And then as he was walking towards the defendant, he was
By
seeing
his
the
own
bulge.
testimony, I think he's asking.
He asked. But the bottom line is now the defense counsel is asking this court to adopt a finding of fact that merely the interaction between him and the defendant made this an authoritative command, which automatically moved it into level two. If this is not a case of a level one benign interaction, I don't know what a police officer could do much more than that, than give somebody candy as well. If this case doesn't amount to level one, then there's no way a police officer can go talk to anybody about anything, because it's immediately, according to the defendant's reasoning, level two. And that makes DeBoer completely unworkable. It reads out level 1.
Or
in the
may be
DeBoer analysis.
unworkable, but nobody, I think, has asked us to overrule it
And I'm
here.
about to, as a matter of fact, to point out that because level 1 and level 2 now are under their analysis, are so meaningless that it may be time, and I'm asking the court to considering adopted in the federal standard, which is you only look to see whether there's a force of, I'm sorry, but the door was open. You only look to see whether there was a force of the seizure.
You know, if the door's open, you walk through it.
Exactly.
Is the door open? Did they challenge Reyes below? He's asking us now to reconsider it.
They didn't. They never raised
So
that
when
below.
was this door opened? The one that you're talking about? No,
Right
no,
now by
I
the
mean,
question.
preserving the claim. I understand you're responding
If this
to-
is what
to the bench.
if their argument is going to essentially be that any time the police interact with a certain level of the population, a certain population, that they feel that they have no ability to do anything but stop and freeze,
Yes.
then essentially he's asking you to read out level 1 and level 2, quite frankly, and look to see whether it's level 3. That's really the logical extension of his argument. If that's his argument, then we're going to ask this court to actually reconsider DeBoer and.
I think he's trying to bump it up to level 2, but
I
fair
understand
enough.
that,
Thank
but-
you, counsel. Thank you very much.
Thank you very much for the rest of my arguments. I rely on my brief.
Thank you. Thank you, counsel. Why isn't he right? Why aren't you just trying to get rid of level 1 and 2?
Yeah, that's all we're doing is asking this court to apply the already established distinctions between level 1, level 2, and level 3.
Do we have to overrule Reyes to do that?
Yes, because Reyes holds that a command to stop
That argument preserved below?
that argument is preserved because counsel expressly says this is a common law inquiry that lacks founded suspicion. To suggest that a trial lawyer has to ask a hearing court to overrule this court is an act of pure waste. The trial court obviously lacks the authority to overrule this court. It is a total waste of time for counsel to engage in that futile exercise. As to the issue with the preservation of the voluntariness charge, I mean, the record is very clear that counsel expressly asked for the charge on the grounds of isolation. He quotes the statute. At 687, he expressly asked for it, just explaining that the facts presented in this case, and it's a byproduct of a coercion contract because Mr. Cisse was incarcerated at the time. That's preserved the
What
claim.
facts adduced at trial about that, though? That's my question.
Well, counsel's
to you.
focusing on the incarceration, and that is
What did he tease out at the trial to support that grand statement of his?
well, he didn't need to tease out anymore.
All right, but then we're back to where we were before, which is your position becomes that anytime somebody's incarcerated at Rikers, you have to give the charge.
Yes, and all we're saying is that federal.
That is a position. We'll think about it.
Thank you.
Thank you.